Good morning and welcome to the offices of Tang Law in Perth. My name is Adam Wood and I'm here today to answer 10 of the most frequently asked questions asked of a traffic lawyer. We've compiled some of your questions here that have come in that I frequently get asked by clients. Question 1. Am I eligible to get an extraordinary driver's license? If you've lost your license and you've already been to court for a driving charge, you may be eligible to apply for an extraordinary driver's license, also called an EDL. This depends on a lot of things and you will not automatically be able to get an EDL. We have to be able to convince the court and the Department of Transport that you should be made eligible to drive under certain parameters and for certain reasons. To do this, we have to apply with paperwork and find out the position of the Department of Transport beforehand. So you need to go to a good driving lawyer to make sure that you put in the best possible application. Remembering, if your application fails, then you have to wait 6 months before you can apply again. You will not even be eligible to apply for an EDL if there are one of 3 situations present. If you have a roadside ban, which is where the police tell you that you're not allowed to drive for a certain amount of time, usually about 2 months, after a roadside infringement. Or if you have a fine suspension for unpaid fines and your license has been cancelled or disqualified for that reason. Or thirdly, if you've lost your license for an accumulation of demerit points. In these situations, you cannot even apply. Question number 2. What is the difference between a cumulative and a concurrent disqualification? Quite a simple answer to this one. A cumulative disqualification adds on to the end of a disqualification that you've already received or that is given for another offence at the same time. So they run back to back and go on for longer. A concurrent disqualification or sentence, however, will start running at the same time as another one. So they both start running together and eventually it means, importantly, you'll be eligible to get your full licence back sooner. Question number 3, will I lose my licence for my driving charge? This depends on quite a lot of information, but specifically we'd have to start with what an individual has been charged with. A lot of driving offences carry with them a mandatory period of disqualification, however. So often the main aim of sentencing is to mitigate or limit the amount of time that you'll lose your licence for, along with any other penalties, including usually a court-based fine. The offences that can lead to a loss of licence are plentiful. So specific advice is needed from a good, experienced criminal or traffic lawyer in regards to your specific situation. We can then tell you at Tang Law whether you'll lose your license, whether you're likely to lose it, and how long you would lose it for. Question number 4, can I get a lifetime driving ban removed? A lifetime driving ban essentially is for life. However, there's always a minimum period of 10 years of the disqualification that you have to serve before you may be eligible to have it removed. It's not a simple situation, and basically the court and the Department of Transport need to be convinced that you should in the situation be eligible to drive again. Similar with an extraordinary driver's license. Now, we have had a lot of success at Tang Law with applications to the court, to the district court in fact, for the removal of lifetime driving bans. Unfortunately, some people even have multiple lifetime driving bans for one person. Doesn't mean that you can't get them all removed after the 10 years has passed. Again, specific advice is needed in relation to the answer to this question as to whether or not you will have a good chance of getting this lifetime driving ban or bans removed from your record. This advice is going to be based on a number of factors, and again, it's very paperwork intensive. So you need to come and talk to a lawyer before you even think about putting in this application, as long as the 10 years of initial disqualification have passed. Question number 5, what does reckless driving actually mean? Reckless driving is one of 3 particular forms of aberrant driving that you can be charged with in Western Australia. There is also careless driving and dangerous driving, which have slightly different meanings and connotations for the charge. The Road Traffic Act 1974 in Western Australia defines reckless driving as driving in a manner that is inherently dangerous or that, having regard to all the circumstances of the case, is dangerous to the public or to any person. What is worth noting though, that despite the grey area as such that can make driving be deemed reckless, it is always going to be considered reckless driving if you are travelling 45 kilometres or more above the speed limit on any road in Western Australia, or if you're driving at over 155 kilometres an hour. That is reckless driving. Number 6, what happens if I don't turn up at a court hearing? If you've been summoned for a charge, then you are sometimes given the option to plea on the paperwork, which means you can sign the form that the court will send you to say whether you want to plead guilty or not guilty, date it and send it to the court. They will then set another court appearance or decide in your absence. This is called an endorsed plea. You cannot just ignore the paperwork, however. If you don't turn up to a traffic charge at court, then they can decide the matter in your absence, or more rarely in traffic matters, they can even put out a warrant for your arrest. This is called a bench warrant because it comes from the bench where the judge or magistrate presides in the court. It is always best to answer a charge in person with a lawyer so you have a chance to defend yourself or to mitigate the sentence. However, your options may be more plentiful depending on how you've been charged. Come and see a traffic lawyer is the answer to this one. Question number 7. Can I go to prison for driving without a license? The definitive answer to this one is yes. If you are charged for driving without a license, it is a charge of no authority to drive in Western Australia. The court does have the ability to send you to prison for this charge. Usually though, if prison is a possibility on the cards for sentencing in a matter like this, it means that you've been charged with the same offence multiple times before, or that maybe you have other charges going alongside it, which makes it an aggravating factor and can possibly lead to a prison sentence being imposed. If a person is facing a charge like this, again, there are a lot of factors that will go into the sentencing exercise. It's always best to see a criminal or traffic lawyer beforehand to get full advice on this one, and it is always best, again, to turn up at court. This is definitely one where individual specific advice is needed for your situation. Question number 8. Should I challenge my ticket in court? If you get a ticket for a traffic offence, it's often an infringement-only matter, which means that you can just deal with it on the paper. Or if you don't go to court or elect to have it heard, then you can be sentenced in your absence. This is for things like low rage speeding, so less than the 45 kilometers an hour that we were talking about, over the limit, which would constitute reckless driving, perhaps running a red light and there's a camera, or going through a stop sign, things like this. These infringement-only offences, you don't have to go to court for, but if you have a valid, relevant defence, you think you haven't done what they've alleged, or maybe they've got the wrong person, then you should challenge it. To do this, you have to elect to challenge it in court, sign the piece of paper, and again, send it in. Always worth going to a lawyer for this one because we can give you preliminary advice which can help you to decide whether or not a ticket is challengeable in your circumstance. This can save you a lot of pain and suffering later in having your license disqualified. Remember, it's too late to challenge it once it's already been to court. Question number 9. What is a spent conviction and can I get one? Well, basically, to have a conviction declared spent, it means that it will still turn up on your record, but the court has determined that you have already suffered the detriment that you should suffer by way of penalty for a charge, whether it be a driving charge or criminal charge. It will turn up on your record still, but with this word spent. That means that employers, often migration and such factors, will not take it into account and cannot take it into account against you. I'm often told by police prosecutors in the magistrates court around Western Australia that they will not declare a conviction spent for a driving offence. This is not entirely true. At Tanglor, we often get driving convictions spent because they can still have a very real ramification, perhaps on your job prospects, your current job, or any other of your earning situations. A conviction can be declared spent at court at the time of sentencing or after 10 years has passed. This is much in the same way as the lifetime driving ban we talked about earlier. So it is important, again, to get good advice. Question number 10, the last of your questions from the frequently asked questions of a traffic lawyer here at Tanglor in Perth. Will the police officer that arrested me be at court? Usually when someone is pulled over for a driving charge, they're pulled over by an on-duty police officer that is serving from the local police station. This person will not be on the police prosecutions team in the prosecutions unit, so they will not likely be at court. However, if you elect to have a charge defended, plead not guilty at court, challenged, then the officer may be required to come in to give evidence in your case, to say what happened, what they witnessed, what evidence there is, and possibly what you or they said at the scene. Now, it is very rare, but occasionally I have known it, that investigating officer or charging police officer is the prosecutor at court. This is only a coincidence and you should not take it personally. These police officers are working on the police prosecutions unit and they will be the ones turning up in full uniform at court. So it may not be the last time you see them at roadside. However, this is only a coincidence and shouldn't be taken against anyone. If you plead not guilty, this is the exception here. So you will see this person again if they have to come to court to give evidence. Again, it is always important to get good, thorough legal advice from a criminal lawyer or an experienced traffic lawyer in regards to whether you should challenge a traffic infringement or a charge at court. This has been 10 questions commonly asked of a traffic lawyer. We're here at Tang Law's offices in Perth. I'm Adam Ward. Please phone us straight away if you need any help with any of your matters, whether they be criminal law, driving related, or anything else. Thank you very much for watching.